So first of all, apologies for my absence over the last couple of days. As many of you probably saw in my community posts, I managed to do the classic ADHD thing of tripping over entirely nothing, landing into a wall and breaking my shoulder. So I'm currently extremely well medicated and struggling a bit in terms of creating content. But I thought I'd try and get this one out in between doses of painkillers just to bring people up to speed. So it seems that Stearns' lawyer has been very, very busy, and I went in this morning to have a look and see if there's any more updates on the trial, just to see if there were any more depositions listed. And I will do a video going through the latest list of depositions soon, but I wanted to jump on this and go through this. I figured the only way I can read these is by sitting my iPad on a desk because I can't hold it. So I thought, well, if I'm going to do that, I might as well set up and record a video. So we have 5 new filings from Stearns' lawyer. One is a motion in limine on trial procedures, another one a motion in limine regarding penalty closing arguments, another one a motion in limine to require state to proffer any and all victim impact evidence, and then we have 2 motions, motion to declare sections 921 141 and or 921 141b or 6b, sorry, Florida statutes and the standard instruction unconstitutional facially as applied. The final one being motion to declare sections Florida statutes jury instructions unconstitutional felony murder. So, like I said, I haven't actually had a look at these, but I thought I'd go through them. Might as well do it with you guys. I apologise, I will probably be continually shifting. I'm wearing a sling at the moment and I keep shifting it to try and make it comfortable. I'm trying to be not so annoying with the noise and everything, but bear with me. Okay, so we have 5 different filings from Stearns' lawyer. So I'm going to push on and I'm going to read through as much of these as I can in one session. If need be, I'll make it a 2-session video. Now, before I jump in, Paula, Plunder True Crime, has been doing a bit of digging and has actually come across a settlement from when Stearns was a kid and got hit by a car. So apparently there was a $10,000 settlement. I will put the link for her video below so you can go and check it out after this. So let's just have a look at these documents that have come out. Okay, so first up we have motion in limine on trial procedures. Comes now the defendant Stephen Stearns by and through the undersigned attorney, pursuant to the defendant's right to due process and right to impartial jury as guaranteed by the 5th, 6th, 4th Amendment of the United States Constitution, blah, blah, blah. They waffle a lot. I think what we're going to see from Stearns' lawyer is a lot of legalese coming through. So files this motion in limine respectfully asking his honourable court to adopt the following 3 trial procedures at the defendant's first-degree murder trial. As grounds in support for his motion, the defendant would show the court as follows. 1. Mr. Stearns is charged by indictment with first-degree murder. 2. The state has filed an intent to seek the death penalty in Mr. Stearns' case. 3. A court's duty to search for constitutional error with painstaking care is never more exacting than it is in a capital case. By this point, it is well established that heightened standards of due process apply to imposition of the death penalty due to the severity, uniqueness and finality of that sanction. So they're basically saying that if there's any errors in the Constitution whatsoever, if there's any things wrong with the law that would make it more likely for Stearns to receive a death penalty, that because it is such an extreme sanction, that the court is basically has to get it right. Now, I should have mentioned before I started, as with other documents, I will put these into my Patreon for people to download if you want the full documents. So if you are not aware, I have a free Patreon. I'll put the link will be in the description. So it costs you nothing to join my Patreon, and it costs you nothing to get these documents. So these are free for all members. I do have a $1 tier and a $2 tier, should you wish to just provide support for my channel. Occasionally, and I haven't come across anything yet, but there may on occasion be things that I put into that $1 or $2 tier because they may be a little bit more sensitive. Certainly there'll be no horrible images ever on my Patreon, nothing like that, but sometimes it may be documents that specifically reference minors or something like that. So if there is a need to just give someone a bit of protection, I'll put those in my $1, $2 tiers. But mostly, if it's a document I cover here, it's going to be free on my Patreon. Okay, so let's move on with this. 1. No judicial qualification of witnesses as experts in the presence of jurors. Of the witnesses the state intends to call at trial, the state has witnesses listed who potentially might be called upon to render an opinion based on the witness's specialised training and knowledge. These witnesses include the medical examiner and analysts with the Florida Department of Law Enforcement, among others the state may call. Under Florida Evidence Code, an expert is a witness who is qualified to express opinions by reason of his knowledge, skill, experience, training and education. A trial judge has broad discretion in passing upon the qualifications of an expert witness and the range of subjects upon which he may be allowed to testify, and the trial's court rulings will not be disturbed upon appeal absent a clear showing of discretion. It is not even necessary for the trial court to state that the witness is qualified as an expert. In fact, it is questionable, emphasis added, whether it is proper procedure for the trial court to declare a witness an expert because the jury may infer from such declaration that the court is placing its approval on the opinions of the witness. The defence submits the proper procedure to handle expert witness testimony is for the proponent to establish the witness qualifications, offer the adversary side the opportunity to then question the witness as to their qualifications if so desired, and then in the absence of a challenge by the non-offering side, for the proponent to proceed to expert witness testimony without judicial labelling as such. The better procedure would have been to permit the witness to testify without reference to his or her status as an expert. So basically what they're saying is they want these experts to prove that they're an expert, which tends to happen anyway in a case. They want to know their credentials, they want to know probably how many trials they've sat at, all that sort of stuff. But they're also saying that they think it's better procedure to have the witness testify without reference to his or her status as an expert. In other words, they don't want, I think they are worried that the prosecution has got some good expert witnesses in who have pretty good credentials, and I think they are worried that the jury is going to be swayed when they discover that these witnesses have good credentials. So essentially, they're wanting to have the jury be less aware of the credentials of these expert witnesses. You can see how that would benefit Stearns, because obviously if you've got a medical examiner who is extremely experienced, and this to me says that there may be something in Maddie's autopsy that is quite damning towards Stearns, they don't want the jury to be swayed by the knowledge that this person is an expert and has been doing their job for 20-something years and has never been wrong. I think we've seen that in trials before where a witness has been cross-examined and it's been proven that they are almost infallible as a witness, and that's what Stearns's defence is probably trying to avoid. So they don't want witnesses to be seen favourably by the jury, basically. Okay, so moving on. The 4th DCA recently held that it is impermissible for the trial judge to label a witness an expert in front of the jury, since this procedure improperly bolsters the testimony of the expert. The Osorio Court noted, while this court and others have repeated the recommendation that trial courts ought to refrain from directly declaring the expert status of a witness in front of the jury, we recognise this has been interpreted by some as merely a suggestion of judicial practice and not a hard and fast rule. So yeah, basically they don't want the jury to see witness experts as witness experts, which I think is a joke, because if someone has got the credentials, if they've got the experience, then that should be recognised, because that certainly adds weight to their argument. It'll be interesting to see what the ruling is on this from the judge. Okay, and the second part here. No mention of grand jury indictment to veneer persons or jurors. Now I have to look up what a veneer or venire person is. Okay, so a venire person is basically a potential juror. So it's anyone during jury selection. So until they are actually selected as a juror, they are a venire person. So when they're doing all the usual spiel before they choose jurors, they're saying they don't want them to hear mention of a grand jury either. So even in the pre-selection period. So nobody that has the potential to be a juror or is a juror should hear that the indictment was issued by way of a grand jury. Unless objected to, judges frequently advise venire persons that the accused has been charged by way of an indictment issued by a grand jury. The defence objects to any mention of a grand jury as being unnecessarily and potentially confusing to the venire panel. More than one venire person has told defence attorneys in the past voir dires that they question the presumption of innocence of a defendant, since some people, i.e. grand jurors, have already made a determination that the defendant committed the crime. If the venire persons are allowed to hear that a grand jury charged the defendant, the defence will have to spend additional time in voir dire, I can't pronounce this Latin stuff, explaining the grand jury process to the veneer panel, and further explaining, by way of that oft-quoted line from law school, that a prosecutor could indict a ham sandwich. By way of analogy, it is the trial court's discretion if a jury is allowed to take a copy of the charges back to the jury room for deliberation, holding that it is not an abuse of discretion for a trial judge to deny a party's request to allow the jury to take a copy of the indictment back to the jury room for deliberations. If it is discretionary for jurors to receive a copy of the grand jury indictment for their deliberation, then it follows that it is also discretionary for the trial court to inform the veneer persons that a grand jury has charged the defendant. It is sufficient to merely inform the veneer persons that the defendant has been charged with 4 counts of first-degree murder and 1 count of attempted first-degree murder. So basically, they don't want the jurors to know that that these charges came down as a result of a grand jury decision, because I think that's going to be prejudicial and convince jurors that he should be convicted. That's a bit of a weak argument, if you ask me, because surely it is up to the defence to explain the purpose of a grand jury is not to decide beyond reasonable doubt, like a jury in a trial, but to decide that there is adequate evidence to make this indictment and to put the charges against someone. So it is a very different thing. I think his lawyers are scrambling at anything they can, because it's such a heinous crime that this guy's done, that they're just going to want to try their best to show the jury as little as possible of the process leading up to where they got there. Okay, so number 3, no reading of the entire witness list by the prosecutor to the veneer panel. The State Attorney's Office has listed numerous witnesses on its witness list in the defendant's case, most of whom are unlikely to be called to testify. Prosecutors frequently seek to read their entire witness list to the veneer panel during jury selection when asked by the court to identify the names of persons who are on the state's witness list. The defence specifically objects to this practice and asks the court to order the prosecutor to read to the veneer panel only those witnesses the prosecution intends to call and those witnesses who are reasonably foreseeable to be called by the prosecution. In other words, there's probably a heck of a lot of witnesses. We haven't seen the actual witness list. So far we've seen a list of depositions by the defence, but we haven't seen a witness list. This sounds like there is quite an extensive witness list, and again, they're trying to do anything they can to avoid making Stearns look guilty. The problem with this is that the whole point of providing a full witness list is because things change during the trial. So you may have this list of witnesses and you may decide partway through that you don't need to use one particular witness, or a witness that you had considered not using, you may suddenly decide that actually it's worthwhile to use them. So I'll be interested to see how the judge rules on this, because I think this could be quite limiting in terms of prosecution, and I think the prosecution would have a lot to say about this. The recitation of all the names of witnesses on the state's witness list, even those who did nothing more than maintain a security perimeter around the crime scene, is prejudicial to the defence in that it suggests that there are more witnesses who may be called by the state than are actually intended to be presented at trial. Improper for prosecution to suggest that evidence which was not presented at trial provided additional grounds for finding the defendant guilty. The defence respectfully asks that the prosecutor read to the venire panel only the names of those witnesses the prosecutor in good faith intends to call at trial, or reasonably foresees calling as witnesses. Moreover, the defence requests that the court avoid any language, direct or indirect, that implies the state has additional witnesses not called at trial. Suggested language by the court might inform the venire panel that they will hear the names of people who may testify at trial, so that no inference is created that additional state witnesses exist that are not presented to the jury. Well, that's a load of hogwash, because in most cases you will have additional witnesses who, for one reason or another, are not presented to the jury. So, yeah, I think they're grasping at straws, but I'd love to hear from people with a better understanding of legal matters as to what your opinion of this is. But it seems to me that they are trying to limit some very basic everyday things that would normally happen in a trial. So at the bottom it says, wherefore Mr. Stearns respectfully moves this Honourable Court to enter an order granted the requested motion in limine on trial procedures. So I think they realise that they're going to have a really tough case by the looks of it, and they want as fewer things as possible to influence the jury. But it'll be interesting, it'll be very interesting to hear the judge's ruling on these. Okay, so moving on. We have a motion in limine regarding penalty closing arguments. Wow. The defendant, Stephen Stearns, moves the court in limine for a ruling directing the state to refrain from making improper comments in penalty phase closing argument. As the Florida Supreme Court has stated, improper prosecutorial comments in closing arguments may be grounds for disciplinary sanctions. Seems to me like they're jumping the gun a bit here and predicting that the prosecution is going to make or violate their prosecutorial duty. So let's have a look down the bottom here, because that's just a really long paragraph there talking about being deeply disturbed as a court by continuing violations of prosecutorial duty. So they're just trying to lump all prosecutors into one basket. Some examples of improper prosecutorial arguments are invocation of religious authority or biblical reference, invocation of a higher authority than the law, injecting the juror's own fear or emotion, admonishing the jurors that they would be cooperating with evil and would themselves be involved in evil just like the defendant by not voting for death. So I can see where they're coming at with this, but I just find it weird that even before the trial, they're essentially saying that they are anticipating that the prosecution is going to make improper arguments. I just find that really interesting. But let's keep going with this. Okay, now I see where they're coming from. Sending a message to the community deterrence that the defendant cannot be walking down the street and gunning people down. In other words, saying if he's not given the death penalty, he might do this again. Well, duh. Golden rule, imagine the pain the victim felt as she drugs herself to the bedroom away from the defendant. golden rule by putting his own imaginary words in the victim's mouth, i.e., don't hurt me, take my money, take my jewellery, don't hurt me. The prosecutor was apparently trying to unduly create, arouse, and inflame the sympathy, prejudice, and passions of the jury to the detriment of the accused. Okay, well, actually, those two really piss me off because, I'm sorry, but we can all imagine the torture that Maddie went through for possibly 7 years of her life. And why should not that be something that is mentioned in the closing argument for the defence? We're talking about a 13-year-old girl, and surely, I mean, you hear victim statements before sentencing, so why should it be any different when you are talking to a jury about whether or not this person deserves a death penalty? Why should it not be allowed to point out the living hell that this little girl went through for possibly up to 7 years of her life? So I think they're trying to silence Maddie's voice here, if you ask me. Don't know the legalities of it, but to me it sounds like they are trying to silence Maddie's voice. They don't want the jury to think about how much suffering Maddie went through. So the next point down the bottom here, misstatement of the law when aggravating factors outnumber mitigating circumstances, death is appropriate. Well, surely if there are a huge number of aggravating factors, and I think there will be with Stearns, as opposed to mitigating circumstances, then the decision probably should be that death is appropriate. I find this a really interesting document. Okay, next point. Misstatement of law, duty as jurors to return a verdict of death. Fair enough. Arguments that if the victim were here, she would want the defendant to be punished for what he did. What's wrong with that? Okay. Inviting the jury to disregard the law if defendant was sentenced to life in prison, he could still be released someday because we all know in the past laws have changed and we all know in the future laws can change. Well, that's probably a valid point. I don't know. Why is that considered disregarding the law? Arguing that any juror's vote for a life sentence would violate the juror's duty. My concern is that some of you may be tempted to take the easy way out, to not weigh the aggravating circumstances and the mitigating circumstances and not want to fully carry out your responsibility and just vote for life. Okay, duty to impose death. I'm going to ask you not to be swayed by pity or sympathy. I'm going to ask you what pity, what sympathy, what mercy did the defendant show? I'm going to ask you to follow the law. I'm going to ask you to do your duty. Attack mitigation as excuses for justification. The prosecutor's attack on Urban's mother as the mistress of excuses, and more importantly, his criticism of her because she never once tried to express concern, that remorse, that sorrow to the family of the victim was likewise improper. These attacks could only serve to prejudice Urban for any animosity that may have been roused in the jury for Urban's mother, hence essentially turning the substantial mitigation of parental neglect against Urban. Sounds like she's just gone and got a whole bunch of cases where arguments have been made basically to try and stop arguments for the death penalty. And it sounds like she's trying to prevent any sort of argument that the prosecution could make for the death penalty. which, I'm sorry, but this guy deserves the death penalty, if you ask me. And this is coming from someone who is an Australian. We don't have the death penalty in Australia. I've never really considered it as something of an option in cases, but with Stearns, I have to say, I really do. Okay, so attacking mitigation as excuse for justification. Every single thing that was presented to you in mitigation, which I really think was one thing, stretched it out to make it more. But it's an excuse. But I don't even get that. Maybe it's just the painkillers muddling my brain. But isn't mitigation, in some regards, justification? Isn't that what it is? Mitigating circumstances are the circumstances which convince the jury to make a decision for the death penalty, yeah? Okay, arguing against mercy. If you are tempted to show this defendant mercy, if you are tempted to show him pity, I'm going to ask you to do this to show him the same amount of mercy, the same amount of pity that he showed Maddie on September or on February 26th, whatever, and that was none. This line of argument is blatantly impermissible under Rhodes versus State. Finding the same mercy argument improper because it was an unnecessary appeal to the sympathies of the jurors calculated to influence their sentence recommendation. And then we've got finding error, where prosecutor asked jury to show defendant as much pity as he showed his victim. Honestly, I think that it's unnecessary anyway, because I think once the jury sees what he did to Maddie, this sort of thing won't even need to be said. I think a jury's going to be pretty strongly opinioned when it comes to this guy. Let's put it that way. Okay, message to the defendant of a life sentence. Now, this defendant wants a life sentence for robbing somebody and murdering them. What kind of message would that send? What kind of message would a life recommendation send to this defendant? As we stated, these considerations are outside the scope of the jury's deliberation, and their injection violates the prosecutor's duty to seek justice, not merely win a death recommendation. Honestly, why doesn't this woman just put in a motion to write the defence's argument for them? Sorry, the prosecution's argument for them. Seems like she has a mega list of things that she believes should be left out of the prosecution's argument. I'm not great with law, so personally I can't see why these things should be omitted. And maybe it's just because I am so much against Stearns that I just want to see the full weight of the law hit him in the arse. Okay, so then we have a paragraph down the bottom here. Comparing defendant to others more worthy, personalising the prosecutor. This blatant appeal to jurors' emotions was improper for a number of reasons. It personalised the prosecutor in the eyes of the jury and gained sympathy for the prosecutor and her family. It contrasted the defendant, who at that point had been convicted of murder, unfavourably with prosecutor's heroic and dutiful father. It put before the jury new evidence highly favourable to the prosecutor. It exempted this new evidence from admissibility requirements and from the crucible of cross-examination, and most important, it equated the prosecutor's father's noble sacrifice for his country with the jury's moral duty to sentence to death. Okay. Denigrating a defence mitigation expert for facts unrelated to his opinion on this case. Comments on defendant's silence. The exercise of legal rights must not be used to enhance statutory aggravating factors. So, by the sounds of that says that Stearns is not going to actually testify in his trial, by the sounds of it. Arguing that life sentence would be a miscarriage of justice. Well, I'm sorry, but I think it would be in this case. Future dangerousness, a dangerous adult who was dangerous from the time he was a child and that he cannot be fixed, all of which suggest a pattern of dangerousness extending into the future. Sounds like she's just basically pulled a whole heap of crap out of other cases and said, well, let's say that you can't say this. I don't know really how much weight any of this would have, but I'd like to think that the prosecutor will be a good enough prosecutor that even if the judge rules on this, that they can still make a pretty compelling argument for a death penalty. It sounds like basically they want the jury to go kindly on Stearns. They're doing everything they can in their power, basically, to prevent him from getting the death penalty. Victim impact. Although the victim impact evidence itself was proper, the prosecutor's use of it in his closing argument, comparing the choices made by the victim and those made by Howard, was improper. It honestly seems to me like all these arguments are a little bit preemptive and a little bit accusatory of the prosecution. To me, these seems like arguments that would, in other circumstances, probably be put forward in a appeal. So I'm not sure what the point of this whole document is. I'm going to keep reading through it though, because this is what the defence is putting out there. Improper argument, non-statutory aggravating circumstance. Improper argument inflamed the passion and prejudices of the jury with elements of emotion and fear by repeatedly using the term executed. Improper argument, the defendant had a character of violence. Prosecutorial expertise. I would submit now that the state does not seek the death penalty in all first-degree murders because it's not always proper, not always inappropriate. So, it really does sound to me like they're basically trying to stop the prosecution from arguing anything about a death penalty, which, hello, that's what the case is about. So the next motion is a motion in limine to require the state to proffer any and all victim impact evidence. Comes now the defendant, Stephen Stearns, by and through the undersigned attorney, pursuant to sections yada yada, Florida statute, Florida rules of criminal procedure, and moves in limine to require the state to proffer out of the presence of the jury any and all victim impact evidence, and as grounds therefore would show as follows. Victim impact evidence, particularly in a death penalty trial, is normally of an extremely emotional nature and has a high probability of unduly, unfairly and unconstitutionally inflaming the jury. You're kidding me, right? Thereby making it impossible for the defendant to get a fair sentencing phase of his trial free of bias and prejudice. I'm sorry, but isn't it just part of the whole process for victim impact statements? Isn't that part of what is taken into consideration? Obviously, this is insane. Paragraph 2. The definition of victim impact evidence in section 921.1418 is vague, ambiguous, and difficult to interpret. In addition, victim impact is not considered an aggravating factor. Right. Paragraph 3. Victim impact witnesses, particularly in a death penalty trial, can be extremely emotional and have great difficulty controlling their emotions while testifying. The defendant, by the filing of this motion, maintains any and all objections to the use of victim impact evidence in its entirety. Wherefore, if the court allows victim impact evidence, the defendant respectfully requests that the court enter an order requiring the state to proffer, out of the presence of the jury, any and all victim impact evidence, so that the court can determine not only whether the evidence is appropriate under the statute authorising it, but that the witnesses themselves are emotionally capable of maintaining appropriate decorum before the jury, so as to avoid unfairly and unconstitutionally inflaming the jury and causing prejudice to the defendant. Okay, this makes me absolutely wild. They want to silence the victims, the ones of the world, and the Stephanies. Screw Jen because, well, she never cared about her daughter. But they basically don't want the jury to see the impact that Maddie's death has had on the people around her. They want to silence that. I think it would be really powerful to hear victim statements from Maddie's friends. These are kids who their lives have been changed forever by this monster. And the defence is worrying about the impression it's going to have on the jury. Well, maybe Stearns should have thought about that before he did what he did to Maddie. Surely it can't be legal to throw out victim impact statements. I really don't see... I'd be amazed if a judge let this one fly. And honestly, I think we're going to see a huge circus yet again with Stearns' case. I think we are going to see motion after motion put out by this defence lawyer. She's just going to basically throw as much crap at the wall as she can to see what sticks by the look of it. So the next motion we have is a motion to declare sections 921.141 and or 921.141(6)(b) Florida statutes, blah blah blah, the standard instruction unconstitutional facially as applied. The defendant, Stephen Michael Stearns, moves that this court enter its order declaring section 921.141 blah 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 Florida statutes and the corresponding standard instruction unconstitutional, and precluding their application at bar for the following reasons. The defendant is charged with a capital homicide in which the state is seeking the death penalty. 2. Among the statutory aggravating factors which the jury may consider at a penalty phase, if supported by the evidence and proven beyond a reasonable doubt, are whether the capital felony was committed by a person previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. B. The defendant was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person. C. The defendant knowingly created a great risk of death to many persons. D. Capital felony was committed while the defendant was engaged or was an accomplice in the commission of or attempting to commit any robbery, sexual battery, aggravated child abuse, abuse of elderly person, or disabled adult resulting in great bodily harm, permanent disability or permanent disfigurement, arson, burglary, kidnapping, aircraft piracy or unlawful throwing. So they're trying to say that he was not attempting sexual battery or aggravated child abuse. They are trying to argue that, basically. So that gives us a bit of a clue as to what they're going to try and argue. Well, maybe not what they're trying to argue, but what they're going to say is not the case. And they're going to, I don't know what they think they're going to do. But even though there's all the photographic and video evidence, it seems like they're going to try and argue against that at the trial and make it sound like it was something totally innocent, which we know it isn't. There seems to be a lot of irrelevant stuff in these documents. The capital felony was committed for the purpose of avoiding or preventing a lawful arrest or effect an escape from custody. Like what? The capital felony was committed for pecuniary gain. Well, we can't be 100% certain of that, can we? Because if there's videos online somewhere that show otherwise, well, hey. The capital felony was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of laws. The capital felony was especially heinous, atrocious or cruel. That could be argued. The capital felony was a homicide and was committed in a cold, calculated and premeditated manner without any pretense or moral or legal justification. The victim of the capital felony was a law enforcement officer engaged in the performance of his or her official duties. I'm not going to read through all these ones because, like I said, a lot of them are totally irrelevant. But you have M, the victim of the capital felony was particularly vulnerable due to advanced age or disability or because the defendant stood in a position of familial or custodial authority over the victim. While technically it didn't count as custodial authority, the fact that Jen had sent them upstairs meant that he did have some authority over her in, like, sort of in a custodial manner. And then if we go down to O, we could argue this. The capital felony was committed by a person designated as a sexual predator or a person previously designated as a sexual predator who had the sexual predator designation removed. Well, I think we can say that he was definitely a sexual predator. Whether or not this means that he had to have been previously listed as one, previously charged, I'm not sure. But, yeah. The state will attempt to raise the prior violent felony aggravator as an aggravating factor during a penalty phase proceeding. Well, given that the only prior violent felony we know of is a sealed one when he was a minor, I don't think that would come into play at all. The prior violent felony aggravating factor of section 921.1416B and its corresponding standard instruction is unconstitutionally vague and overbroad and has been applied in an overbroad fashion and in an arbitrary and inconsistent manner. Because this unconstitutional circumstance has been and constitutes to be used as a basis for imposing a number of death sentences in this state because its unlawful use makes proportionally review arbitrary and because its bare terms are all that is required to be read to sentencing juries. 6. Its standard instruction and the death penalty as applied in Florida thus violate the 5th, 6th, 8th and 14th Amendments to the United States Constitution and Article 1, Sections 9, 16, 17, 21 and 22 of Florida Constitution. I'm totally lost. I think they are trying to say that they can't argue that he did it as part of a sexual assault on Maddie, or they're trying to argue that they can't bring up the prior offence, which I would imagine they wouldn't bring that up anyway because it would be considered inadmissible. But it seems like they are looking at any sort of thing that could be used against Stern and trying to claim that it would be unconstitutional. But honestly, I think I need you guys to help me out with this, because I'm just not getting it. This is a capital case in which the prosecution is asking this court to impose the death penalty. Accordingly, heightened standards of due process apply. In reviewing death sentences, the court has demanded even greater certainty that the jury's conclusions rested on proper grounds. Reliability in the fact-finding aspect of sentencing has been a cornerstone of the Supreme Court's death penalty decisions. Where a defendant's life is at stake, the court has been particularly sensitive to ensure that every safeguard is observed. A death penalty statute is unconstitutional if it has standards so vague that they would fail adequately to channel the sentencing decision patterns of juries, with the result that a pattern of arbitrary and capricious sentencing could occur. A capital sentencing scheme must genuinely follow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. Florida statutes set out the rule for construing provisions of the Florida Criminal Code. The provisions of this code and offences defined by other statutes shall be strictly construed when the language is susceptible of differing constructions. It shall be construed most favourably the accused. This principle of strict construction is not merely a maxim of statutory interpretation, it is rooted in fundamental principles of due process. I'll skip through all that. Great care is needed in construing aggravating circumstances. Well, I think aggravating circumstances are pretty easy to construe in this case. He was an adult given charge over this child. How can you misinterpret that? I think they are grasping at straws here. I think they are just going to try everything in their power to avoid a death penalty, but I think that the statute actually is quite clear. The first problem with the Florida Supreme Court's application of the circumstances is that it does not require the prior conviction be used as a basis for imposing a death sentence to be final. Even a conviction pending on appeal may be used as a circumstance. Such an interpretation violates the due process and equal protection rights to an appeal and the Eighth Amendment narrowing requirements and prescription that death sentences cannot be predicated on mere caprice or on factors that are constitutionally impermissible or totally irrelevant to the sentencing process, or on materially inaccurate information. Okay. The second problem is the expansion of the circumstance to permit contemporaneous violent felony convictions to be treated as a prior violent felony. Florida permits any conviction prior to sentencing to be treated as a prior violent felony even if that conviction arises from the same criminal episode as the capital felony, and even if the capital and other charges are tried together. While the court has limited the contemporaneous conviction circumstances to preclude its use where there is a single victim, that limitation does not save the circumstance. The court's interpretation is not related to the purpose of the circumstance to punish more severely those who have committed violent crimes in the past. The individualised assessment of the appropriateness of the death penalty is a moral inquiry into whether a person convicted of first-degree murder has a history of violence, and exposes those who have no history of conviction for a violent felony to a greater likelihood of receiving death. What? The broad application of the circumstance thus fails to genuinely narrow the class of death eligible, is wholly unrelated to blameworthiness of the particular defendant, and relies on conduct that is irrelevant to the sentencing process. I don't see how this actually applies to Stearns' case, but if anyone can give me some notion of how this applies to his case, let me know. Now, I'm not going to read through this final motion, because honestly it looks to me like all 5 of these are much of the same thing, and that is that they are trying to silence the prosecution, trying to prevent them from actually speaking in support of the death penalty, which, in my opinion, Stearns deserves well and truly. I know I probably haven't offered a lot of great insights in this video, but I have to say there's just so much legal speak. I don't know if it's just my brain's a bit fuzzy from all the medications that I'm on, or if it is just a whole heap of gobbledygook, but it honestly just seems to me like a desperate attempt to prevent the prosecution from saying anything that would convince the jury of the need for a death penalty. As I said, I've put all 5 of these documents up in Patreon now, so if you want to go have a look at them for yourselves, you can go and download them there. It's free to join my Patreon. All the documents are free, so it costs you nothing. All you've got to do is just, I think you've just got to have an email address and subscribe, that's all. I suspect that the docket may have looked at these as well, just from looking at what's been popping up on my YouTube this afternoon. But I think I'm tapped. I feel like I'm just reading a bunch of gobbledygook right now. That's basically, the gist of it is that they're going to try everything in their power to avoid the death penalty, which that's their job, but I feel like some of these things are grasping at straws quite a bit. So I'll leave it at that. I will be doing another video probably tomorrow now, which is looking at the most recent list of depositions, and I also have a few other videos planned, ones that are pretty much already queued up but I haven't gotten to. I had quite a few videos in the works when I injured my shoulder, and they've just been sitting there waiting for me to actually be able to do it. I apologise. I can only manage to work for about 20 minutes at a time at the moment. So it is going to limit the amount of videos that I can get out over the next couple of weeks. On that note, I do want to thank everyone who did offer me their well wishes, and everyone for their prayers and their thoughts and everything. It's certainly been a somewhat painful, challenging couple of days, and it sounds like it's going to be a somewhat long road to recovery. I I basically have to sleep in an armchair at night at the moment because of my shoulder, which is not fun. But enough about me. Thanks for listening. If you are new, please subscribe to my channel. Also, please hit the like. YouTube loves that and gets my videos out into the algorithm. And leave a comment below. Let me know your thoughts on this. Do you think the defence team is just, desperately grasping at straws? Or maybe you've got a better understanding of this than me. Maybe some of you will go and grab the documents and read through them and come back and give me a better idea of what you think is going on here. I look forward to reading all your comments. So on that note, thank you for listening, and I'll catch you in the next one.